Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We are here for our Tuesday night live program. Thanks for joining us. We'll give a couple of seconds for some other people to join us as well. Obviously, it's Tuesday night. We're live. We're going to talk about the Bryan Kohberger case. We'll probably talk a little bit about the P. Diddy case, probably talk a little about the Karen Reed case, and anything else that basically piques my interest, or a comment that you all want to talk about as well. We will do that. And like I said, for those who maybe haven't joined us before, my name is Scott Reich. I'm a practicing attorney, been doing primarily criminal defense and complex civil litigation for the last 30 years, primarily criminal defense. But litigation is litigation is litigation. It really doesn't matter. It all comes down to who can find the best facts. So I've been doing this for being an attorney for 30 years, been doing Crime Talk here for 6-7 years, I do believe now. And we're this close, almost to 300,000 subscribers. Just need like 7,500, 8,000 more subscribers. We'll be at 300,000, which, you know, for a part-time gig, that's not too bad. I don't know if you ever, it's hard. It's hard work. You don't just put a video up and miraculously become a YouTube influencer, to say the least. It takes a lot of work, consistency, and hopefully we put out a good product. That's why we're building it up. And who knows, maybe one of these days we'll get to 1 million subscribers. I'll quit being a lawyer, quit that day job, and just focus on this. I'm going to do this one week. I'm going to block out an entire week, and I just want to do live from like 9 to noon. A three-hour show every day, talking about what is breaking in the legal community, particularly true crime. But let's face it, everything revolves around the law. Everything. All right. So let's talk about the Bryan Kohberger case. We put up a video today about why does Bryan Kohberger like Ted Bundy, maybe models himself after Ted Bundy. Maybe it's just a coincidence. Maybe he just does that for research, for his PhD program, or maybe he's just a weirdo. Maybe he is just out there, doing research on Ted Bundy. It's possible. I mean, anything's possible, right? But I want to know, and Bryan Kohberger, hey, I'm a defense guy. Nobody would love to see a great trial and, see it, a long deliberation, whether he's guilty, not guilty, all that good stuff. Nobody would love to see that better than me. I love good lawyering. It's like going to any sort of sporting event and seeing, good competition, right? Good football game, good team battles out. But obviously, the courtroom is a little more realistic in life because it really affects people's livelihood and their potentially their liberty as well. So, I want to see that. But I think the kind of thing that always jumps out at me is, remember that you got the Bryan Kohberger, not just the fan club, like we're going to give him the benefit of the doubt, but the women who are like, oh my God, he's so sexy. Like, really, if this guy wasn't charged with quadruple murder, would half of those women give this guy the time of day? My guess is apparently not, based upon all the information that we have. This guy was quite awkward and what's the word I'm looking for? Not very smooth with the ladies, so to speak. I mean, I don't think he ever really had a girlfriend. We did a show the other day. Think the guy's got some lady issues, issues with women. I don't know. Maybe his mother didn't breastfeed him long enough. Who knows what the issues are, right? They're trying to come up with anything to save this guy's life. And, there was the Dateline special last Friday night. I can't believe it that I was watching Dateline on a Friday night. That's usually the last thing I would want to do. But I watched it, and frankly, there wasn't that much new information that came out. We saw a new video in regards to the alleged car that they believe is that of Bryan Kohberger speeding away from the house. There was a little bit, new information, but for the most part, we've heard about it. We've talked about it here on Crime Talk. But at the, excuse me, at the end of the day, whether Bryan Kohberger was a ladies' man or whether he liked Ted Bundy probably doesn't matter. Probably doesn't make a hill of beans difference as it relates to the evidence. In fact, most of that probably will not come in to evidence because, you know, what relevance does it show? Because it really has nothing to do with any of the victims in this particular case. So it's probably not coming in. What is really, I mean, what's obviously the biggest thing, and we've talked about this before, and some people think it's no big deal. I'm telling you, ladies and gentlemen, I've tried DNA cases. I've tried fresh or, you know, warm DNA cases. I've tried cold DNA cases, and DNA matters. Okay. You have to be able to explain how it got there. Think about it. Let's say, for example, somebody comes into the Crime Talk studios, takes the Crime Talk K-bar that their beloved host has had since 1986 when he graduated from Marine Corps boot camp, had it yet again when he went through Officer Candidate School, and had it his entire time, you know, on active duty and in the reserves, and still has it today. And I managed not to lose it. But let's say somebody comes in here, wants to attack me at the Crime Talk studios. Okay. And let's say, I don't know, it's you. For show of hands, it's you. Your DNA just happens to be here, right? You could say, well, how did my DNA get there? I mean, sure, Scott's, you know, now stabbed to death. He's there. He's the sheath is underneath my arm here, right? As I lay here, and as I'm lying on the floor, the police come and take a look at it, and they swab the sheath. And you know, there's probably my DNA because I've touched it, right? It's semi-smooth, you know, probably leaving some stuff there's kind of rough, you know, leaving my DNA there if they came in and they swabbed it and they could, you know, do the extraction, all that good stuff. But they don't find it, but they find you. And then they go and look at your phone that you're in the vicinity. Maybe you're driving around my building. Okay. Doesn't take a rocket scientist to figure out that maybe you were there. And you say, well, you can't say how my DNA got there, can you? No, I can't. You can't say that, you know, you borrowed it. Scott gave me permission and I borrowed it weeks in advance. He said I could do it, but he took it without his knowledge. And you can come with any different scenario you want, but it's not plausible. And how are you going to prove it? You're not going to prove it. Okay. You can ask hypothetical questions. Sir, you cannot say, and don't get me wrong, I know you can ask these questions because I have done it. Okay. Cross-examined many a DNA expert. Said, sir. Now, certainly you found DNA on the item that was collected at the crime scene. Now, you can't say when it got there, can you? No. You can't say under what circumstances it got there, can you? No. All you can say is it's there, right? Well, yes, it is. And the district attorney then will get up and say, and what's one more time for the jury, sir? Why don't you explain to the jury what are the odds that would be somebody other than the defendant's DNA at the crime scene? And they say, it'd be a chance of 1 in 567 octillion. How many zeros is that, sir? After the 1 in 150 octillion. Oh, that's like 50 zeros. Oh, so more people than are on the face of the earth, the odds of it being someone other than the defendant. And juries go, got it. So I know there are people out there say, it's just touch DNA. It's DNA, ladies and gentlemen. Your DNA's there. Not there. My DNA's not there. Frank, the hardest working man in show business, producer, is not there. And we're not charged with murder now, are we? What are the odds? Okay, Carla says he obviously must have been at a party there, right? That'll explain all the times that he was out driving around in the wee hours of the morning around 1122 King Road, right? Driving around. He's at a party. Okay. Now you can say and go into transfer. Let's talk about transfer, right? More than likely, if it's a smooth object, right? Like let's say a glass, nice smooth object, you can probably see, you can transfer, smooth objects, fingerprints, transfer, right? I could blow on it. I could even drink from it. And maybe I would leave some of my DNA there. But let's say, for example, I have a glass, I drink out of that glass, and maybe you drank out of it, and I touch it when I pick it up, and I'm going to put it in the dishwasher, and then I just happen to come back in here right before I leave, and I grab the Crime Talk K-Bar, which, unlike Bryan Kohberger, allegedly, I've been managed to hold on to this for 37 years. He couldn't even make it 12 months. Anyway, the odds of transferring that DNA from my glass to the underneath portion of this particular sheath, 1 in a million. And I get it. Okay, he was at a party there. Okay, what date? What date? And more importantly, what witness are you going to call to present that evidence? Right? District attorney's going to get back on cross-examination. You know, sir, you've looked at this case. You're the lead detective on this case. Do you have any evidence to believe, other than the night of November 13th of 2022, was Mr. Cobberger ever invited into that house in any way whatsoever? No. Have you spoken with anybody that's been able to provide any information about Mr. Cobberger being there? No. So do you have any evidence that he knew anybody in that residence? He had any contact with? He had any reason to be in that residence? Even if there was a party at that residence and he was apparently there, what evidence do you have? And what date was it there? I have no evidence of that. Just asking the question is not necessarily evidence. It's the answer, right? You can't just ask the question and say, that's evidence. Sir, isn't it true that Mr. Cobberger was at a party at that? I have no evidence of that. What's the evidence in evidence? There's no evidence that he was at that house for a party. Just throwing out a hypothetical is not evidence, ladies and gentlemen. It's not. You have to be able to have legal and competent evidence to get it into evidence, right? It has to be a legally permissible question, a legally permissible answer, and you have to have a witness with personal knowledge. That's why in criminal cases, you know, the confrontation clause, people have to come to court. You don't get to phone it in, so to speak, write an affidavit, right? People are always, well, can't I just write an affidavit? No, it's a criminal case. You got to come to court and be subject to cross-examination. So how are you going to get that in? Now, I don't know. Maybe the defense on their proposed witness list will have a key witness that will somehow clear Bryan Kohberger, or will somehow put Mr. Cobberger there voluntarily, which would explain why, coincidentally, the knife sheath that he bought may possibly be the same one where he happened to, you know, purchase it and he can't find his knife. Oops, can't find it. You can't do it. I mean, maybe there's going to be a person on that witness list, you know. Defense never has to do anything. They can try to raise reasonable doubt, but they don't. But there were 2 new filings today. Nothing really sexy at all. First, motion to seal parties' joint proposed jury instruction regarding tip leading to investigation of the defendant. So let me read this and then we'll talk about it. Comes now the state of Idaho by and through the Latah County prosecuting attorney and hereby moves this court pursuant to Idaho Court Administrative Rule 32 GI and Idaho Code Section 74-124, subparagraph B, for an order sealing the parties' joint proposed jury instruction regarding tip leading to investigators based upon the fact that all jury instructions have been filed under seal. So all the other things have been filed under seal, so therefore we need to do it. Based upon the parties' joint proposed instruction regarding the tip, the court does hereby confirm an order that it is exempt from disclosure and sealed pursuant to the rules. So we will add this to the stack of filings that we have in this particular case. We keep on the Crime Talk desk here. And these are the recent ones. I got another big stack over here just in case we need to reference them, ladies and gentlemen. Yes, we've read them all. We've read many of them to you, if not all of them. It just keeps getting bigger and bigger and bigger. Okay. But why? Why do we have to seal the proposed jury instructions? They're proposed jury instructions. You can submit anything you want. This is a stipulated jury instruction regarding the tip. Remember, the defense in the Bryan Kohberger case moved to suppress basically all the evidence in the case against Bryan Kohberger because they believed that his DNA was obtained improperly through the FBI use of the investigative genetic genealogy. The crux of their argument was that the FBI didn't follow their own policy, the key word being policy, guidance, proposal, the way we should handle things, but not a law, where they, said they usually wouldn't go into these genetic genealogy websites, but they did in this particular case, but they didn't violate any laws. Anyway, the court denied it, and then the rest of the motions that the defense filed faded away, crumbled, crashed and burned, wasn't pretty. They got zilch, they got nada, they got nothing. Zilch, zero, nada. I mean, they got a couple little things here and there, but not anything that's going to sway the jury in any particular way. Bottom line, that's just the way it is. All right. And so, even though the defense really went after the genetic genealogy, wanted everybody to know how unfair it is. Remember, they wanted it to all be open to disclosure because they're trying to, let the people know that they weren't following the rules, so to speak. And then the judge threw that out and said, well, that's, no, that fails. And hey, you guys didn't even, didn't even challenge the DNA, the search of the crime scene. Not that you really could have, because it was abandoned, right? It was an abandonment theory. If you're walking down the street and you throw your backpack because you think the cops are following you and you have drugs in it, you throw it away, you're abandoning it. You can't then later come back and say, I have standing to, I want my backpack back, and it was an illegal search. No, you abandoned it. You threw it away. Kind of like if you leave something at the crime scene, you abandon it and leave it. It is what it is. It's just there. And, I think as time has gone on, the conspiracy theories about the government planting the DNA on the crime scene, on the knife sheath, have pretty much dissipated because there's no credible evidence. And like I said, man, listen, I'm a defense guy. Nothing brings me greater pleasure than beating the government. Okay? Nothing brings me greater pleasure than beating the government. However, I've said it and I'll say it again. Any good defense attorney cannot ignore the facts. Sometimes you got to embrace them. Sometimes you got to go take, the gut punches and go try the case, even though you're going to lose it, just because everybody needs to know that you're going to go try the case and you're going to do everything you can. And if they're going to get a conviction, you're going to make them crawl over glass, they being the government, to get it. Do you guys want to be reasonable? You want to be unreasonable? I can be unreasonable. There's an easy way to do things in the hard way. You guys want to be reasonable? Give me a reasonable offer. You don't want to do it the reasonable way? We'll go to trial. But here we are in the Bryan Kohberger case, right? And the evidence, the stage has been set, ladies and gentlemen. I think the defense in the Bryan Kohberger case have another 2 weeks, I think, to submit their alternate suspect. Remember, back at the hearing in March, they said they have a tip that could lead to an alternate suspect. Now, I know there's a gag order, but if there was an alternate suspect that they thought was going to clear Bryan Kohberger, now understand, the fact of an alternate suspect coming to testify, slim to none, because let's say you're accusing that person of, committing a crime. Guess what? First of all, you got to understand the legal hurdles to get there. Second of all, if you can't call that person to the stand because they're going to assert their Fifth Amendment right against self-incrimination. So how do you get that in then? Then you have to try to say, well, through other witnesses who have personal knowledge, that this is the person that must have done it. And alternate suspect is tough, ladies and gentlemen. I don't know, hundreds and hundreds of trials. And rarely have alternate suspect, I think we've done it a couple of times, right? Where you say, this was the person that did it, the real burglar, the real killer, because they've done it before and they'll do it again. Pretty tough to come up with that one. Now, obviously, the general defense of general denial is more than likely what Bryan Kohberger is going to go with. General denial. Didn't do it. Prove it. You can't prove it. That's what it is. Going to hold the government to the burden of proof, right? And really, a general denial is kind of an alternate suspect in and of itself, right? Think about it. We've talked about this, and if we had the jury instructions that are so secretive, and let me tell you, there's nothing secretive about jury instructions. They're published. Look at over there in the corner, not this corner. That's my United States Supreme Court certificate. That corner over there. It used to be the jury instructions came out like once every 10 years. Now they have committees that come out every year. They modify jury instructions. They have a jury instruction for every definition, for every crime, whether it be obviously a criminal case or even on the civil side. They have the civil jury instructions. They have all the stock instructions. You go there and you say, these are the instructions for murder. You pull that out, you plug in the right names. Without the affirmative defense, the defense is going to have a couple of instructions, right? Maybe general denial, which is the standard one, says, ladies and gentlemen of the jury, the defendant has entered a plea of not guilty. They never have to prove anything beyond a reasonable doubt. That's it. Defense usually doesn't have a whole lot of instructions. The standard instructions for homicide, pretty straightforward. Well, let me just do it. Let me just grab one. Okay. Come back here. So this is an older version, but we always keep them around because you never know when you're going to get an old case. Like I said, did an old homicide like 20 years ago. Had to go back and get the jury instructions for that time because they were tried under the law at that particular time. All right. So let me just show you how this works, ladies and gentlemen. I don't understand why they're sealing this stuff in there. General directions for use of the Colgi, criminal jury orientation, general instructions, evidentiary instructions, final charge, definitions, individual and corporate culpability, inchoate crimes like conspiracy, defenses, insanity, culpability based upon behavior of another, crimes of violence. Then we get to murder, right? Let's go to chapter 3.1. Okay. And they're all pretty much the same. Okay. I have done trials all over the country and it's all the same. We were talking about this just the other day. Having attorneys like, oh, I'm gonna get start doing federal work. I'm like, great, you can do it. Federal work is easy. You're the only thing on the docket. You have the judge's undivided attention. It's absolutely wonderful. It's not like going to state court where there's 60 cases set on there at any given time. So they're all basically the same. Now, like I said, this is a Colorado instruction, but they're all the same. All right. Every jurisdiction does this now. It's so much easier. They all copy the same laws. Most of this stuff is exactly the same. Let me get here. This is all the crime of violence instruction. All right. Murder instruction. Do it so you can see it, right? The murder instruction. There it is. Murder in the first degree after deliberation. The elements of the crime of murder in the first degree after deliberation are: one, that the defendant, right? Because they have to prove that it was the defendant, not somebody who looked like the defendant, not somebody that used the defendant's identity, but it was in fact the defendant, proof beyond a reasonable doubt, that in the state alleged, at or about the date and place charged, after deliberation, and with the intent to cause the death of another person other than himself, cause the death of that person or another person, and that the defendant's conduct was not legally authorized by an affirmative defense. And then they would give that instruction if there was, like self-defense. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree after deliberation. Okay. Then you go into little footnotes here, and it says, see instruction F10, defining after deliberation. Instruction F185, defining intentionally and with intent. Go to then instruction F267, defining a person, right? So let's go to F185. So like I said, they have definitions for everything that's needs to be defined in the law, and that's developed either through statutory construction, where the legislature has defined it, or through case law over the years. So, but then we go to instruction F185, right? So why is this a big secret in Idaho? A person acts intentionally or with intent when his or her conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial to the issue of specific intent whether or not the result actually occurred. Okay, after that's intentionally. Let's then go to after deliberation. F10 instruction. That's the one I really meant to read. Sorry. F10. So then we go to definition F10 in the standard stock instructions. The term after deliberation means not only intentionally, but also the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner, right? And, you know, the classic definition of after deliberation, okay? Think about this, ladies and gentlemen. After deliberation can happen so quickly. Think about it. Let me give you an example. After deliberation, and not just like going in and going to stab somebody with my K-bar, right? Let me give you this. Who's been driving down the road? You're driving down the road, and you're getting to that big intersection. You're driving, you're still a little bit of distance away, and you're driving and you're getting a little bit closer. And you think, wow, that light's been green for a little bit. Yeah, that light's been green a little bit. I'm going to start maybe keeping the pedal because, you know, maybe I'll go through it, but maybe I'll slow down. And anyway, right as you get kind of that decision point where you think, I got to make a decision to go or not go, the light changes from green to yellow. And then you make that decision just like that to either apply the brakes, realizing everything around you. Do I have enough distance to stop? Is the guy behind me going to hit me? Is somebody going to run the red light? Does it just turn red? Is it not? I got a little time to go for it. But the point is, you did it just like that. And you did it after deliberation. That is how quickly one can do something after deliberation, right? It's not like, you know, somebody walks up to you and they just happen to punch you and you just, you know, swing around, hit the guy back, you know, kind of reflexively, and, you know, you pop him in the nose and he has a glass chin or whatever, falls back, hits his head on the ground and has a brain bleed and dies. Probably not first degree murder after deliberation, probably second degree murder, right? manslaughter perhaps, but not first-degree murder. Okay. So I guess my point is, once again, why is Idaho always so secretive, right? They file all these motions in secret, and then ultimately they get an order comes out and gives us these little tidbits, and that's where you're going to find the best information on any case. It's not going to be, from what you hear local. You got to go read. You got to go read the source of it. You got to go read the actual documents that have been filed by the people outlining the case. Okay. In this particular case, like I said, why do we have to have such secrecy in Idaho? I mean, if the court says file your proposed jury instructions no later than this date, you file them, right? Like, it is what it is. You go to the book, right? Heck, most prosecutors don't even do their own jury instruction. Most judges don't even do their own jury instructions. There was a great judge years ago, Judge Hobbs. She was fabulous. She would, a lot of judges say, have the prosecutor or the plaintiff's attorney, prepare the jury instructions. And then the judge just kind of, thumbs through it. Yeah, do we need this? Throw this one out, put this one in. The judge was like, nope. If the case is coming back on jury instructions, it's going to be my responsibility. So I'm going to do it. And she would always do all of her own instructions. And obviously the defense can submit instructions, but there has to be some scintilla of evidence. Scintilla, itty bitty tiny little bit of evidence, right? To get there, to get the instruction. Where does that come in? Usually affirmative defenses. I don't anticipate any affirmative defenses. It's not like Bryan Kohberger is going to say, you know what? You're right. I did it, but it was self-defense. He's not going to do that. He's not going to do that. So once again, like I said, why is it such a big secret for proposed jury instructions? Now, this proposed jury instruction that the prosecutors and the defense have come up with as it relates to the IGG information that's going to say it's a tip, it's going to say something to the effect of, and obviously I don't have it, but it will come out eventually, and I think I will be right, where the instruction will say, the parties have stipulated that a tip led the police authorities, the FBI, to investigate Bryan Kohberger, which ultimately resulted in the taking of his DNA, right? There's going to be some stipulation of that particular fact. And if it's a stipulated fact, it is considered proven. All parties agree to it. Now, the defense doesn't want to go into all that IGG stuff that, is his dad and how they did it and, how they got it. He's out going through the, there's just going to be a lot of stuff that the defense doesn't want in. Okay. The defense, sometimes you want a lot of stuff to come in, but in this case, Bryan Kohberger stuff, it's just a little weird. Then you got to start explaining, like, why is he wearing rubber gloves to take out the garbage? I've taken out a lot of garbage in my days over the years. I get told by the lovely Miss Kristen, although she loves taking out the garbage. I don't know why, but occasionally she'll put it by the back door and know that I'm going towards the trash can, and she will do that. But not once have I ever put on rubber gloves to take out the garbage. Maybe I don't have an OCD issue, but I don't like getting dirty with the garbage. But the point is, the reality of it is, you got to start explaining all that stuff. And the defense isn't going to want to have to explain all that stuff. They're going to want to keep it simple. When the video of the car driving away and you really can't tell what it is from the particular view that they had on that Dateline show the other night. Sir, you can't really see from that picture what kind of car that is. The light seems to, blind it out, wash it out, doesn't it? Well, yes, it does. Thank you. Right. Then they're going to get up and say, well, let's talk about the next video. Where'd that one come from? And do you have a better shot of that white Elantra driving there? Oh, you do? So yeah, thank you, Carol or Carla. Thank you, Carla. Sorry, Carla M. Thank you for the super chat. We don't beg and grovel for super chats, but we always appreciate them. And if you do that, it also highlights, well, your comment, and then we get to read it live on the show. Yep. Sorry, Carla. AI screws up my typing. Well, thank you for the super chat. And hopefully I'm trying to explain it. That was always been our goal of the show, to explain things a little more in depth, right? You hear the nightly news, they got 15 seconds to talk about a case. Usually the people have no idea what they're really talking about. And so that's always been our goals, hopefully educate people about the law. So now you know there's a book with all the jury instructions, right? Let's just randomly pick one. Internet sexual exploitation of children. Guess what? There's a jury instruction for that. Let's go here. First degree arson. Oop, got one of those. Guess I better read that. That the defendant in the state of Colorado, at about date and place charge, knowingly set fire to, burned, caused, or burned, or by the use of an explosive, damaged or destroyed, or caused to be damaged or destroyed any building or occupied structure of another without the person's consent. Right? You got them for every single crime. In fact, now it's so big, it's a 2-volume set. I just saw a brand open page. Interference with persons with disabilities, false impersonation, selling, transferring, or dispensing marijuana to a minor, more than 6 ounces, but not more than 2.5 pounds of marijuana. Because if you blow those amounts, apparently it's okay, right? Possession of drug paraphernalia. We've got every definition literally for every offense. Cybercrime, pretenses, defrauding somebody, criminal possession of financial transaction device. Now, you know what? I love this one. And this is what I love. True story. All right? True story. And this should be disturbing to everybody. Okay? Police see a guy driving a car. They think, that car has California license plates on it. I should run that. So the police look at it. They type it into their little computer. And they say, that's funny. We can tell through all the toll tracking devices on the highway that car drove overnight from California and is now in Colorado. Let's come up with a reason to stop it. And the people don't speak great English. They speak Chinese. Anyway, police ultimately get into the car. They find a bunch of things what they believe to be gift cards. They're not really sure what to do with it. But so I go to the preliminary hearing. I'm like, these guys have no clue what they're freaking doing. So I go to the elements, right? And when you go to a preliminary hearing, you have to establish per se evidence of each and every element of the crime for the case to move forward. So just a little side note, war story here. So I say, all right, Trooper Schmuckatelli, you're out there, right? And you're doing everything right. Let's talk about that. You pull them over. And then you find out that there's all this stuff in the car, right? Yeah. And so I just literally started going through the elements of the offense, right? And it was a criminal possession of financial transaction device. So I said, the defendant possessed the device, the account holder, only if the defendant possessed from 4 more devices, or at least 2. Oh, those are the instructions. Sorry. That the defendant, financial device. Anyway, it was all this stuff that they had to go through without permission, a lawful authority, applying for, completing an application for a device with the extension. It just went on and on and on, right? And all the different things. And the cops literally look at me like, what are you talking about? No, I have no idea. I have no idea. And the beautiful thing was that he was so dazed and confused by the time he got done, the judge had to dismiss the case. So first thing you always do whenever you have a case, particularly if it's like a statute you're not familiar of, and even if you are, I always tell my attorneys, go to the jury instructions, go read the statute, see what the cases are that have interpreted that, see what the cases that have said, oh, you have to give this particular definition, don't modify it, because this is the law. And sometimes we overcomplicate so many things, right? Like I said, when you go to the instruction for murder that we talked about, right? Pretty straightforward. Murder in the first degree. Everybody always makes it so complicated, right? Look at this. That the defendant in the state charged on or about the date and place charged after deliberation with the intent caused the death of another person other than himself and without an affirmative defense, right? That's it. Where was the instruction about motive? Well, they had to have a motive. Motive is never an element of the offense. Why do people do things? I've had people do stuff for the sport of it. Maybe they're just bad people. I had a case once where they stabbed a guy in prison. It was a federal case. And they stabbed a guy in prison because he squirted, I don't know, the cleaning solution on the microwave when the guy was microwaving his cup of soup. And there was an exchange of some type, like, why are you like, is it going to contaminate the item inside being microwaved? Anyway, the guy got upset, goes back to his cell. It's all on video, and comes back and, stabs the guy on the stairs like 8 times with like a pick-like instrumentality. Why did he do that? What was his motive? Because he was upset that they cleaned the microwave, that they was cooking his cup of noodles. I mean, that's a ridiculous motive. Maybe he's just got a really bad temper and he can't control himself. Is that really a motive? No, but it explains a lot, doesn't it? Maybe why he's in, federal prison and will be for the rest of his life. And that's why he goes around stabbing people. Maybe he's just not wired right, ladies and gentlemen. But what's that? The instructions are usually quite simple. It gets complicated when we start getting into the computer crimes and things of that nature. But the reality of it is it's pretty straightforward. So the bottom line is everybody makes it more difficult than they need to be. Everybody creates all this speculation, there's no motive. Why would Bryan Kohberger go and kill those people? Does he need a motive? Maybe he just wanted to. Maybe he didn't do it. Maybe he's been wrongfully accused this entire time. The police, because they were so confused as to who did this, they obviously, not knowing whose DNA was on that knife sheath, planted the evidence or came up with the IgG just to get Bryan Kohberger, but they didn't know whose the DNA it was. So I'm not sure how they could frame him if they didn't know that was it. And they had the knife in evidence before they knew the knife sheath in evidence before they knew who he was and before he got arrested. So it was pretty unlikely. And they'd already done the DNA profile and it didn't match in CODIS, which means he'd never been arrested. So it doesn't make a whole lot of sense that the police did something nefarious on that. And if they're going to lie about it, that's going to come across. This is what most people don't realize, is that cross-examination is the greatest truth-seeking tool ever created. And I mean that. You see stuff on TV, right? Particularly you watch like these political shows or whatever, and some people, they say something and it's outrageous. And then the other person talks over them and doesn't let the other person, talk, or the other person won't answer the question that's asked to explain it. Well, that's the beautiful thing about court. Only one person gets to talk at a time. And when you're asked a question and it's deemed relevant, you have to answer that. And guess what? Most of the time, the person asking the question knows the answer to the question that they're asking. And if you say something different, you hold them up and say, well, isn't this true? This is what you said. This is what happened. Oh, yeah, I guess so. Well, why were you not telling the truth? Well, I don't know. Well, maybe I forgot. Maybe my memory wasn't that good. Maybe I couldn't see that well. Cross-examination is the greatest truth-seeking tool ever invented. I swear, if I want to have a debate show one day, I mean, wouldn't it be the best debate show ever? Like for politicians, literally put them in the stand. The one party gets to ask a question. The other person has to answer it. No speeches. Answer the question. And if they don't answer the question, I guess that's your answer now, isn't it? Right? And then you switch them around. And the judge, you ask him a question. You did this. You did this. That's not true, right? They don't get to do their little spin. That would be great. And that's the greatest thing about our criminal justice system, right? The confrontation clause in the United States Constitution is the greatest truth-seeking tool ever invented. The truth or a pretty close version of it will come out. I always tell that to my clients. If it's a civil matter, I have a similar conversation. Dude, the truth is coming out, man. You can just might as well just come on clean, right? Because I got a civil case, and I don't even have to prove it beyond a reasonable doubt. It's a mere preponderance of the evidence, more likely than not. Like, I never get it this easy. And so that's where we go. That's where we go. Okay. It's the greatest truth-seeking tool ever created, and that's why the truth is going to come out. And when people come up with these crazy cockamamie stories, right? And don't get me wrong, I come up with some of those crazy cockamamie stories too. I just don't put them on the record because I would sound like a fool, right? I mean, we've joked around, right? Your client's charged with murder, and the person shot in the back like 6 times or stabbed in the back 6 times, whatever. It doesn't matter the matter of death, the means of matter. It's just that the person's dead, right? Your client's charged with it. And it's like, obviously it's a suicide, right? That's stupid. It's joking, but but I would never say that in court, right? Maybe jokingly with the district attorney. It's obvious the guy committed suicide. Really? Come on. Set my people free. And they're like, oh, that's funny, Scott. Yeah. But your guy got, my victim got shot in the back 6 times and your guy's on video doing it. Oh, really? Is that all you got? Right? How do you know that's my guy? How do you know that gun was his? Sure. DNA left it at the scene. Shell casings matched the gun found on him later. Oh, fine. Sure. Is that all you got? Okay. But I guarantee you, ladies and gentlemen, the Bryan Kohberger defense team, they are sweating the DNA. They're sweating it. Why do you think they tried to make it go away so hard? Why do you think they tried to do that? I've told you this before, and I will say it again. You can always tell the bad evidence in the case because that's the evidence that the defense is trying to suppress or keep out through a motion in limine. In some way, saying that it was obtained illegally, motion to suppress, motion in limine, not relevant, or if it is relevant, it's so prejudicial, judge. And the judge says, well, unfortunately, Mr. Defendant, oftentimes the evidence is prejudicial. That's why it's, inculpatory towards the defendant. So I guarantee you, ladies and gentlemen, the defense has probably had all these conversations about how that DNA got on that little sheath below the body or arm of Madison Mogen. And they probably talked, well, obviously, somebody stole Mr. Cobberger's knife from his apartment in Washington, Pullman, Washington. Then they probably go ask, hey, did anybody steal your knife? No. Even if it did, would a police report have had to be made? Probably helpful. Yeah. Let's see. Who else could we call to testify? Oh, only Bryan Kohberger for that. Not going to be Bryan Kohberger calling to testify about that. No. Huh. So we can't go with that. Well, obviously he probably had a party. He was there at a party, right? Yeah. He was at a party. Well, they got all his GPS phone data going back for quite a while. Huh. I wonder if there's any evidence in his GPS phone data that he must have been there for a party. Let's go check that out. Oh, no, there's none of that either. Huh. So now what are we going to come up with? Well, obviously, a lot of people buy K-bars. No, No, they don't. No, they don't. I don't know. Maybe somebody could do a quick search on that. How many K-bars were purchased last year? I guess we could probably call the company. But most people that buy the K-bars are young Marines. When they get out of boot camp, they're like, I want a K-bar. I'm going to attach it to my web gear. And I'm going to keep it on me here. So, in case I ever need to cut some paracord or dig a little hole out in the field. Never know I need to open an MRE. I better have a K-bar on me. Most people don't necessarily buy a K-bar to keep it. They go in a lot of shadow boxes, right? When people retire from the military. And it's not like you're in the Army and you're going to buy a K-bar. You're not going to do it. Not that many people buy a K-bar. It's not like you're going to carry this around in your belt, because it's a little longer than what most people, most states allow for something that's not considered, too large to carry around. Usually it's just a little pocket knife, less than 3 inches or something. So, yeah, that's it. And then you got the whole, it got there. It must have been some transfer. We talked about that. Really, 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 really. I mean, I give that example all the time. Got the DNA person up there. Sir, madam, you're a DNA expert. You can't say how that DNA got on that firearm in my car where the shooting took place, can you? Well, no, I just know that it's there. I just tested it. Yeah, but you can't say when it got there, can you? No, you can't say who placed it there, can you? Let's talk about transfer. Sir, we can transfer DNA, can't we? Well, yes, we can. So, for example, if I come up and shake your hand, right, since DNA is going to be in the oils or the skin cells, right? There's a chance that if we shook hands and then we came and swabbed your hand and my hand, that there would probably be a mixture of DNA there. Isn't that true, sir? Well, yes, that's normally what happens when there's a transfer like that, right? Oh, okay. And they said, well, let's talk about this podium. Could you imagine how many people at this courtroom podium there have touched this? All the defense attorney, all the prosecutors, all the pro se defendants that have come up here and their palms are sweaty and they transfer this oil onto the smooth surface where you could easily take a swab from. We'd probably have a lot, wouldn't we? Well, yes, it would depend, but it also depend. There'd be a lot of people that touched it where it didn't stay because maybe they didn't touch it long enough or hard enough for it to transfer. There's so many variables on it. Maybe the weather degraded it, right? The environmental circumstances degraded it. Oh, okay. But more than likely, the fact that, DNA get put on this little part right here, right? Originally right there. Remember, we originally thought it was this part, and then we learned more about it. Like, oh, there it is. That makes sense because these little buttons are hard. You got to push on it. Yeah, you're applying there. Oils from your skin, the DNA, right? You're getting it right there. But then we find out it's this one right here. Ooh. What are the odds that obviously Mr. Cobberger must have shaken the hand or come in contact with the real killer, and that his DNA transfer was so intense that not only did it get transferred to the other guy, now remember, the guy with OCD is probably not going to go run around shaking other people's hands. Just throwing that out there, something to think about. But the DNA is transferred to that other person, and that then person, the real killer, just happens to get a K-bar purchased just like Bryan Kohberger did, and happens to transfer, coincidentally, Bryan Kohberger's DNA that just happened to be underneath the deceased body of the victim. Right? Completely plausible, ladies and gentlemen. Do you think the defense is going to make that argument? No. Get for real, ladies and gentlemen. That's why I'm telling you, as a defense attorney of 30 years, everyone's like, oh, you can't. Doesn't matter that there's DNA there. It doesn't matter. Yes, it does. And if you don't think it does, you've never tried a criminal case where there's been DNA. Okay. The only time it really doesn't matter is, well, maybe the crime is committed in the defendant's house. Well, of course you're going to find DNA there, right? Maybe a sexual assault. You're going to say, of course there's going to be DNA from the sane nurse examination because they engaged in sexual intercourse and it was consensual. Of course I'd expect it to be there. But when you got a quadruple homicide, three beautiful young ladies, a handsome young man, stabbed to death violently with a K-bar while they slept. And apparently a couple tried to fight off the perpetrator. Quadruple homicide. You don't want your client's DNA there, ladies and gentlemen. You don't want your client's DNA there. Because guess what? Although the defendant doesn't have to do anything, the jury's going to be looking at it and say, I know he doesn't have to prove anything, but I haven't heard any good reasons why his DNA would be on that knife sheath of the murder weapon. Right? I don't know. Maybe we should go to some of the questions to see. Does anybody think I'm absolutely crazy with these various analyses of the DNA evidence there? Kylie, your other countries. I'm not aware of any countries. Like I said, you can find DNA. If you can come to my desk, you come to Crime Talk desk here, touch there. Probably got DNA. Maybe it gets wiped away when the cleaning people come in and they wipe it down so conveniently every night. I'm telling you, that's a stretch. That's a stretch. Because you know what those DNA people are going to say? Yeah, it's possible, but not very plausible. And that's what matters. What's funny? Oh, are you drunk, dude? I'm Julie Ariana. Am I drunk? No, I don't drink. I am totally stone cold sober. The hardest thing that I drink is Red Bull. Keeps me on my toes. Tell me then, Ariana, tell me what plausible explanation you would have. If you're going to go with that theory, that the real killer must have come in contact with Bryan Kohberger, transferred his DNA, kept it there so calmly and discreetly, waiting for the perfect moment to put it right there on Bryan Kohberger's knife sheath or the sheath of the real killer and getting away with the perfect murder. It's going to be tough. It's going to be tough. Okay. It's going to be tough. I'm telling you, I've done, I don't know how many DNA trials over the years. Heck, I did DNA trials when DNA wasn't scientifically proven, right? We had to have Shrek hearings on it. And, well, I'll just tell you the facts of the case. And, it's one of those things we've had some explaining to do, right? So I'm a young defense attorney. I'm in the Marine Corps. And I get this senior official Marine, senior charged with sexual offenses. He liked getting young Marines liquored up. And he had a little workshop that he had. And he would literally take these young Marines out there, male Marines, and the jury convicted him of his peers of sexually assaulting them. And throughout all the years, allegations that come up like, whoa, that dude's a little weird, right? But he was the epitome of the perfect Marine. I won't go into all the details of it, but ultimately, throughout the years, allegations came up. They quashed all those allegations. How dare you make an allegation against such a reputable Marine? How dare you besmirch him? Oh, we're going to ruin your career. Anyways, years go by. The guy does the same thing. Takes young Lamb's corporal, gets them all liquored up, tries to take him out into the woods, perform some, various things on him. Dude like freaks out, like, whoa, what's up, Gunny? That's a little weird. Immediately goes to make the report. They take a little swab of the young Lance Corporal's genitalia. And guess what happens to be there? My client's DNA. Now, how do you explain how that got there? Right? You had an eyewitness. We went to trial. Ladies and gentlemen. The defense was it never happened. Can't trust that DNA stuff at all. That stuff can get there anyway. Practically transfer. Blowing in the wind, I guess. It doesn't, ladies and gentlemen. Okay? It doesn't transfer. You can think, I cough, and suddenly my DNA is going to be all over Frank. And if Frank, winds up dead, they're going to swab Frank and, find my DNA on him. Scott must have committed the crime. It doesn't work that way. Anything's possible, ladies and gentlemen, but plausibility is really what it comes down to. Okay. So take it what you want. Like I said, I would love to see a great trial. I mean, if I was Bryan Kohberger's attorney, I would be doing everything I could to win that case. I would. And I'd be making the same arguments that his defense attorneys are making. But he's got a tough road to hoe. And the problem is they've got that pesky DNA. And I don't care what world you live in, you cannot ignore those facts, right? Now, we jokingly say, why are we going to let the facts get in the way of a good defense, right? Yeah. Now, you joke about that stuff, but the reality of it is you have to be able to embrace those bad facts or be able to explain them away, say they mean nothing. So, that's the way that is. Let's see here. I saw something about touch. Dude only turns his phone off in the night. It's touch DNA because it came directly from Cobberger. Kitty cat, no dear. Let's go and move on with your life. Okay, let's see here. And I'm not trying to say, hey, I'm like I said, anything's possible, but it's got to be legal and competent evidence. They think the K-bar knife fits, but they don't have it. I agree. How many other people, though, if you notice the K-bar knife, they've been making these the same way since World War II and beyond. They all have the little Marine Corps Eagle, Globe, and Anchor on there. Okay. Once again, the reason why most people aren't going to buy it. My guess is Bryan Kohberger probably maybe thought he always wanted to be Marine, but he couldn't hack it, right? Probably because he had these mental things and everybody probably put him on a bunch of drugs. I see these young kids these days, I'm on this drug and that drug. Like, dude, you want to go in the military? Like, you want to be a pilot or, anything like that? Like, don't do that. But everybody wants to put everybody's kids on drugs. I remember my son, this is how crazy it has become. My son was a very, very good golfer when he was in high school, and he played golf at the Air Force Academy, where, he didn't have as much success as he did in high school, but he was still a very good golfer, and he's still a scratch golfer to this day. But at one point, my kid's going to be the next Tiger Woods, right? What can we do to help him out? At one point, we sent him to a sports psychologist. And when he was applying to the Air Force Academy, they're like, have you ever been seen by a psychiatrist, a psychologist? And they're like, oh, you've seen a psychologist? Oh my God. Like, what, are you suicidal? What's going on? No, I was just trying to improve my golf game is what he said. But they had to have a doctor write a letter for it and this and that and everything else. And I mean, I don't know. I don't even know how we got onto that, but it's just legal and plausible evidence, right? We talked about it. It's there. Bryan Kohberger. Oh yeah. He probably wanted to go into the military. Couldn't. So he wanted to do the next best thing. He says, well, if I'm going to have a knife, I'm going to get a K-bar because, well, let's face it, the Marines are the best. And so I'm going to have a knife, right? Because Marines are killers, right? I tell you, it's a terrible knife. Terrible, terrible knife. Like I said, this one's 37 years old. I think I'd have a better shot of hurting somebody if I threw it at them and hit them in the head with this end than sharpen it. I've never been able to get this one particularly sharp. I don't want to put it up here because it's live. We don't want anybody to think that I'm going to hurt myself, right? We did that once with our antique gun when we were talking about a case, and they demonetized it because they said, "Oh my goodness, you can't have a gun, even though it's an antique. There are no bullets for it." And we were explaining the Alec Baldwin case, and they said, "Well, you had a gun and it was live, and how do we know you weren't gonna do something? Did you watch the video where I was explaining the hammer and how it came back and the revolver and all that? Doesn't matter." Anyway, so Bryan Kohberger gets this. Like I said, they don't have the knife. No. And there's a reason. Maybe that's the reason why he went back. There's no reports of it. No police going by. Maybe nobody's in the house. Maybe I should run back in and see if I can find my knife sheath that I left there, allegedly. What do they say? They always return to the scene of the crime. Isn't that what they say? Yeah. Anyway, there's a lot of, it's going to be an interesting case. And don't get me wrong, I want the defense. I want Bryan Kohberger to have his day in court because the Constitution matters. All of those trial rights that we talk about, it's for real. It's constitutional rights. Somebody asked a question. Have you used your giant K-bar knife you got as a gift? I didn't buy this as a gift. I bought this myself when I was a young Marine and graduated from boot camp. 1986, ladies and gentlemen. I'm sorry. 88. 16 June, 1988. I go to boot camp. Marine Corps boot camp, MCRD, San Diego. Graduate. Everybody's got to get a K-bar. And of course you get one and the leather's stiff and the knife's so shiny. You look like such a boot, right? I'm going to put it to my web gear and look at me. I'm hard. I'm going to the field. Oh, look at me. I got my K-bar. Guess I need to open my MRE or dig a little hole in the desert somewhere. That's what it's for. But when the Bryan Kohberger case was like, they said K-bar, I've got one of those. So anyway, they don't have the knife. I'll give you that. But they have a knife sheath. And most people don't carry around a knife sheath unless they have a knife in it, at least at one time. But then, of course, if it's involved allegedly in a quadruple homicide, you probably don't want to be found with that. So I think it's reasonably plausible that one would throw it away, maybe in a river or something, driving back to Washington State, or potentially a dumpster along the way, right? And I'd probably do it before I turn my phone back on. Anyway, let's see here. Corrupt FBI. What was that one? I just think there's no way to come to a decision without seeing all the evidence. Karen, I agree. Let's wait and see. There may be some bombshell evidence out there for the defense that we just don't know about. I mean, it's probably like an alibi. Oh, nope, don't have that one. Huh. Possibly the alternate suspect. Nope. And don't get me wrong, I'm not a huge fan of the police, right? I love them. I have lots of friends that are police officers, acquaintances that we get along well, mutual respect. But I'm a defense attorney. Been doing it for a long time. But generally, ladies and gentlemen, I have to say that I can't really think of a case where they framed my client. Now, does it happen where they get people to falsely confess to something? Yes. But we don't have a false confession with Bryan Kohberger. No. Yeah. No, don't have that. I mean, the car, the license plates, he, after the homicide, he's lived in Washington for over a year at that point. suddenly decides, you know what, I think it's a good time to finally get those Washington state license plates. Enough with those Pennsylvania license plates. Enough of that. Now I do, I don't know. We'll see. We'll see. I hope. And now, you know what has been the biggest hindrance to the defense in this particular case? And it's not because I don't think he's particularly biased in any way. Judge Hippler. Judge, he loved Ann Taylor. She got whatever she wanted. That judge seems like a very nice man, but he just did not have control of that particular courtroom, and he was going to let the defense do it. If he was still the judge, we would do this trial in about 2029, ladies and gentlemen. This Judge Hippler is moving things along. I love it. That's the way it should be. I mean, start to finish, most criminal cases shouldn't be more than a year. Good homicide, year and a half, 2 years at the most. Here we are, almost 3 years by the time we get to trial. And I don't care if it's death penalty or not. I remember I had this death penalty case, trying to do mitigation. Judge, I need more time. And he's like, yeah, no, let's just move along. The old job expands to the amount of time given. That's what happens. So anyway, all right. So I guess you probably know how I feel about the evidence thus far. Although I am, Scott, if you were representing Cobberger, would you handle it like Ann Taylor? I think Ann Taylor's done an excellent job for her client, Mr. Cobberger. She really has. I think she's been a zealous advocate. Now, don't get me wrong. If he loses and he gets death, they will be throwing her under the bus, saying she was ineffective, didn't do, something right. It's just the nature of the business. She knows it. And I think she is a, death penalty, anti-death penalty enough that she'd probably say, you're right, I was ineffective. Yeah, I probably would have done that different. Only thing I probably would have done differently is, because money's really no object in a death penalty case, even for the defense. The judge even said that. Well, did you ask for more money if you need help reviewing stuff? I would have got more investigators on the case. That's what I would have done differently. Okay. You can hang your hat on filing all the motions to suppress you want. You can file all your motions eliminate, trying to keep out the particular evidence. Yes, you do that. But the reality of it is the motions to suppress is only as good as the judge you're in front of. And this Judge Hippler seems nice. I don't think he seems afraid to granting a motion to suppress if the government screwed up, but he wasn't granting any of this stuff. I would spend less of my time on some of those legal issues or delegate that much more to somebody else and spent more time in doing investigation, because bottom line is, ladies and gentlemen, most cases, particularly homicide cases, do not rest on the matters of law. They never do. The law is pretty well settled. The case law is pretty well settled. And it's usually against the defendant. Just the reality of it. So you have to be prepared to go to trial and come up with the best facts, right? Send everybody out there, speak to everyone at the Washington University that even if they thought they ever crossed him, right? Passed him on a walk. Everybody there digging up dirt on somebody. Who else did these people have? And I'm sure they've looked into it, but that's really where the facts are going to come in. That's where you're going to find your alternate suspect. That's where you're going to find somebody to explain, the other glove, who, where'd that glove come from? Who manufactured it? Where was it sold? The one that was found outside. How many were sold in Moscow, Idaho? How many in Pullman, Washington, or the surrounding area? What size was it? Maybe try to go out there and find who's it. Could have been that guy. Oh, that's interesting. And his hands are all cut up. Huh, interesting, right? I don't know that. I'm just saying, hypothetically. But that's what I would have done. Most cases don't hang on the law. Everybody always thinks, I'm going to file a motion to dismiss and the case is going to get, no, you're not. You're going to file your motions. You're going to use it as a tool of discovery, but for the most part, it's going to be denied. That's just the way it is. You're the defense. And if you can't be a defense attorney and handle losing quite a bit, even when you think you're right, it's not the job for you. That's for sure. But that's what I would have done differently. People are going to question things that don't add up. I don't know if he's guilty or not, but I will not blindly believe things that don't make sense. Okay, but that's what trials are for. All right. Remember, we don't have all of the information yet. That's why we got to wait for trial. And maybe there's some great evidence for the defense. I don't know. But remember, everybody always thinks you're going to get some perfect explanation of it, right? And remember, a trial is like putting together a puzzle. Everybody thinks you're going to get this one witness and it's going to be that Perry Mason moment. Wasn't it true the one-armed man was the one that spoke with Bryan Kohberger and transferred his DNA and had the K-bar and went in there that night? And yes, the one-armed man did it. You don't have those Perry Mason moments very often in court, ladies and gentlemen. Every now and then you get a great cross-examination. We're like, wow, that went better than I thought it was, right? Or you have something like the trial I just did, like, man, she's really not prepared. This is great, right? But usually it comes down to who has the better facts. And so to think that it's just going to, there's going to be this one little, this smoking gun. No, it's like putting together a jigsaw puzzle, right? The classic thing is you get a picture of the defendant and you cut it up like a big jigsaw puzzle. And you say, you're putting the pieces together. Oh, you had this witness says this. And you got the car that says this. And you got the DNA that says this. And you put all those little pieces together, right? You got the DNA, the evidence, the car, the consciousness of guilt, the Amazon knife, boom, boom, boom. And next thing you know, by the time you put all the pieces together, guess what? It's a picture of Bryan Kohberger. And just remember, not everything has to make completely absolute sense. Some of the most bizarre things I've ever heard. Like, I literally really? I've had clients tell me stories and you're just like, really? You want me to believe that? Really? Really? Like, dude, I'm telling you, this is the way it happened. And sometimes some weird and freaky stuff that you can't explain happens, right? And I've had clients where I go back to the office, like, oh, geez, call an investigator. Dude, investigator, you need to go check this out. Client says this. I know it sounds total BS, but go talk to the people, right? And it turns out to be true. Because people put themselves in some crazy situations. And usually the more crazier situations, the more likely someone's going to wind up dead or someone's going to wind up getting arrested. And you just think, I thought I've heard it all. I thought that I've seen it all. And then somebody does something and you're just like, how did that happen? It defies logic. It doesn't make sense. You don't think it's humanly possible. But you got people, you got adrenaline, you got emotions going. And some bizarre stuff sometimes can go down. Okay. I wonder if your clients have ever told you the truth, if they did or not. I wonder if your clients have ever told you the truth. Yeah, I have clients tell me the truth all the time. I have no problem with that. Doesn't mean you can't represent them. Frankly, I like it when clients tell me the truth. At least I know what I'm dealing with, and at least they're being honest with me, which means that I've established trust with them. I tell people all the time, man, I've won more cases when client doesn't testify. And if you said you did it, guess what? You're not testifying. So we're going to argue the reasonable inferences or the lack thereof in the evidence that's been presented or not presented. Some truth is stranger than fiction. Judge told me that once. That's right, Vanessa, because he's probably seen some stuff that that's some freaky stuff, man. I'm telling you, it's weird stuff, man. I'm telling you. Why do you think defense attorneys are always invited to cocktail parties? Because we got the best stories ever. Most people are like, oh, that couldn't have happened. Oh, yeah, it did. Let me tell you. Okay. So anyway, all right. Is it ethical to represent a guilty client? Absolutely, Muhammad. Everybody is entitled to a defense attorney under the Sixth Amendment to the United States Constitution. Remember, the Constitution matters. And on top of that, I've represented people that it's on videotape. And I said, ladies and gentlemen, my client is not guilty. The prosecution has to prove the case beyond a reasonable doubt. All it takes is an allegation to get through those doors. And now the prosecution has to prove it to each and every element of the defense charge. And when you hear all the evidence, they're going to say not guilty. Make them prove the case. No matter how overwhelming it is. You can say, you know what? Like I had a guy once, he was living in Supermax. Got in trouble in some prison and some, fraudulent stuff and maybe beat some people up in a holding cell that were testifying against him. Like I put in the wrong spot. My dude, he had already been in prison like 20 years. He'd beat 2 death penalty cases. I said, what? I said, you're on video, dude, kind of beating the guy up. What do you want to go to trial for? He was like, dude, I'm down in Florence. This is like a vacation for me. He's like, and did you see how smoking hot that court reporter was? Let's sit here all month, he said. Okay, let's go do it. Let's go do it. Whereupon a jury of his peers promptly convicted him. Never seen a happier man in his life. He got a vacation being down in Florence. He got to sit in a low security detention facility pending his trial. And in his words, he got to look at a smoking hot court reporter for the week. Happiest man you ever seen in your life. I remember he goes, now do the appeal. I'm like, really? There's no issues. He goes, do the appeal. Okay, you got it. You got to do the appeal. And I remember the first question the 10th Circuit asked me, Mr. Reich, I noticed that you said at sentencing that this appears to be somewhat academic. Why did you say that? Well, Your Honor, I think what I meant was because my client's serving multiple life sentences plus like 60 some odd years based upon a multi-state jurisdiction crime spree where he killed police officers in 2 jurisdictions. And so really this one doesn't really matter. He'll never get around to serving that. Now I was a little more eloquent than that, but those were the facts. He's like, why are you doing the appeal? Well, Your Honor, he asked me to do the appeal. I know I didn't want to do the appeal, but I was obligated to do so, Your Honor. He asked me to. I didn't say that, but they knew what was going on. Whereupon they promptly were like, yeah, judgment affirmed. So yes, Mohammed, yes, you can represent guilty clients. Yes, you can. All right. Raquel, I like it. I love Scott's court stories. I'm telling you, if I could just go back there, like, I'll pull a file. Oh, let me tell you about this. Oh my God, this would be so great. I won't mention any names, but my God, some great stories, man. And also some very sad ones. I think I mentioned this before. I was thinking about it. I hadn't thought about it in years. And then one day it like popped up in my head, but I had a client and then I'll let you go. We got to go do our Patreon show, but it was terrible. I'm in court and I get this call and I don't recognize the number, but I go, yeah, what can I help you with? Oh yeah, I'm Scott. Who is this? This is Detective so-and-so. We got a standoff situation with your client. Your client would like to speak with you. Oh, okay. Well, we want to put him on? Like, is he there? Well, no. We're in a standoff situation. He's holding his son hostage. Would you come down here and maybe talk to him? He wants to speak with you. Sure. I'm in court. Let me see if I can get out of here. So I go up there. I drive up there. And I'm there at the command center, this and that. I talk to my client, everything. Hey, come on, man. We'll work it out. We'll get it all. It'll all be okay. And then all of a sudden you hear like the SWAT team goes in, bang, 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 boom, 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 boom. And you're just kind of sitting there waiting like, what's going on, guys? They start tearing down the command post. What's going on, guys? Is it over? Yeah. All right. Did you get my client? Oh. You mean he killed his son and then either killed suicide or you guys got him? Yeah, that's pretty much what happened. Okay. All right. Like, well, I guess I'll go back to the office and get some work done. I mean, like, what do you do? Right? How many people get to experience that in any given day? I mean, I should just come in here one night. We'd have a great show. just get about 4 attorneys and just sit and talk about all our war stories. Yeah. Kitty, yay, Melendez brothers sentenced to 50 to life. Was that today? I thought that was later in the week. Yeah. Was that today? I'm going to have to disagree with that one. I think those Melendez brothers are evil. Johnny, I agree. Cobberger's knife is in the Snake River, and some fishermen will be out there in 20 years and fishing it out of the river somewhere because it gets tangled up. All right, so Menendez brother 50 to life, which means they're basically eligible for parole. Those are some bad dudes, right? I mean, seriously, and I but good for them. Good for them, I guess. 30 years is a long time, right? Because when you're in prison in there, those hours turn into days, those days turn into weeks, and those weeks turn into years. It's so slow. So I don't know. All right. Well, if you'd like to enjoy the conversation or you'd like to continue the conversation because you've enjoyed the conversation, we're going to take it over to our Patreon show for, I don't know, 30 minutes or so, depending on how many people show up and seeing how many people are chatty, but it's just a small group of Patreon members. And the beautiful thing is, well, we'll put up the call-in number and you can ask me anything you'd like to talk about. After all, it's your show because, well, you're the Patreon member. And I think it costs a whopping $5 to do that is the minimum. You can do more, but $5 ought to do it for you. It's a lot of fun. And we'll send you some free stuff if you do, in fact, sign up. So we'll see you there. Thanks for enjoying the show. I hope you enjoyed the show. Thanks for watching. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. In fact, we'll put this one up as well tomorrow. Have a wonderful night. And remember, the Constitution matters.
All right, lawyer.